As promised, circling back once again to the Duncan v. Bonta lawsuit. That's our challenge on Prop 63's magazine ban here in California. We're going to get the two-way attorney's take on the Ninth Circuit opinion, the mandate that recently came out, and where this is likely going. Let's talk about it. Hey everybody, welcome back to the channel today, and as discussed, we are circling back to the Duncan v. Bonta case. To talk us through that today, we have brought back the volunteer president of CRPA, that is Michel. Chuck, thanks for being on today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, before we get into this today, please, as always, be sure to like, share, and subscribe to this channel. It's a great way for you to directly contribute to the fight here for the Second Amendment in litigative and legislative efforts with CRPA. So Chuck, let's just jump right into it. As I discussed in the video last week, and as we discussed right when this opinion came out, we wanted to circle back after a couple of read-throughs of the opinion. We've got the Ninth Circuit, who has, again, even though told them to even though the Supreme Court told them to reconsider the case after Bruin, has come to the same conclusion. There's been some time elapsed here. So what is it that we take away from the opinion in this case from the Ninth Circuit?
Well, recall this is an en banc opinion. Duncan case was filed in 2017. So here we are 7-8 years later, finally getting an opinion out of the en banc panel in the Ninth Circuit. That's the 11-judge panel. And the 11-judge panel ruled 7-4 that a magazine that can hold over 10 rounds is not an integral part of the firearm. It's an accessory. Now, there's a false distinction there. So if it's a 10-round magazine, then it's an integral part and it is the firearm, but if it's an 11-round magazine, it's not. As an artificial distinction, any magazine size is still an integral part of a firearm. And just because a magazine can hold 11 versus 10 doesn't make the difference. If it did, then any change on the gun, whether you get a better trigger or a red dot sight or a more ergonomic grip, the state could essentially ban any upgrade of a firearm and dumb your firearm down to a slingshot. So the four judges that ruled that this law is unconstitutional made that point emphatically. In fact, Judge VanDyke, and he'll be on the cover of the next Firing Line magazine, demonstrating in a video. That was an unprecedented move. Part of his dissent incorporated a video that's on the Ninth Circuit's YouTube channel where he breaks down his handgun to all the component parts and shows any of these parts can be interchangeable, and any of these parts could conceivably be characterized as making a gun more dangerous, depending on what your definition of dangerous is, because that's what the state was saying about why an 11-round magazine can be banned, because it's more dangerous than a 10-round magazine. I mean, it's definitely tortured logic designed to allow judges who don't want to strike down a gun control law to uphold it. In the meantime, though, we're going to take that case to the Supreme Court again. It's already been there once. And the last time around, the 11-judge panel ruled the same way, 7-4, and their decision was vacated. And then we had to try the case again down in San Diego in front of Judge Benitez. It made its way back up to the en banc panel. They sat on it for a year before they finally ruled. So now we'll take it to the Supreme Court. In the meantime, we requested that before this Ninth Circuit ruling go into effect, that the court give us a chance to ask the Supreme Court to take the case and do what it's called stay the mandate. When a court rules, the opinion, the ruling, does not become final until a mandate issues. It's just a technical kind of part of the procedure of finalizing an appellate court ruling.
And I do want to get into that mandate with you, but before we leave this thought, I'm kind of curious what your thought is on this. If you zoom out a little bit and look at legislation and litigation as a whole, we have people who are acting for the state. Those are the state's attorneys who are arguing that something like a magazine is an accessory, it's not a firearm. At the same time, we have legislators for the state who are making law, who are trying to make bills and laws that, I mean, in this instance, there's a 2025 bill that is trying to essentially categorize barrels as firearms so that they can regulate those in a way, forcing us to do background checks. Can you explain this tightrope walk that we as gun owners have to go through?
Yeah, you're talking about, I mean, technically speaking, trying to not make this too legalese. What is an arm in the right to keep and bear arms? It's not statutorily defined. There's a legislative understanding. The founders had an understanding about what an arm was, and in order for the right to keep and bear arms to mean anything, it can't just literally mean you can have one arm, one firearm, and the state can regulate all the parts that go all the way around it as long as it shoots one bullet, then it's an arm. It's much, much more than that. Arms, right to keep and bear arms encompasses training, encompasses going to the range, encompasses hunting, target shooting, sporting clays, anything that has to do with the shooting sports or using a firearm for the self-defense is encompassed under the right to keep and bear arms. So the Ninth Circuit is trying to drill down on what an arm is under the Second Amendment. Meanwhile, in Sacramento, they have a statutory definition of a firearm, and they're trying to expand, and basically it's the frame. That's considered to be the firearm, not the barrel, not the trigger, not the grips, not the parts. Just so you can be prosecuted for having an unassembled frame concealed in your car. A case just came down that said that, even if it, obviously it's a piece of metal or a polymer or whatever, it's not functional. You can't pull a trigger without a barrel. It doesn't have a trigger. It's just the frame. So that was typically what's been known of as the actual firearm. So if you put all these parts on it, it didn't make it a firearm and take away from it being a firearm. Now what the state wants to do is start regulating those parts. So they want to regulate barrels, and now you have to get you have to serialize the barrel and get pass a background check to buy a barrel. It becomes this hugely cumbersome process to acquire, to be able to change out a barrel, for example, on your firearm. And it's all part of just trying to red tape the right to death. That's what the legislators in Sacramento are trying.
Well, I'm sure, and that essentially is why we advocate against bills like those. And that is a pretty good distinction, though. So in Sacramento, they are talking about specifically firearms, and in the courts, we're arguing about the right to keep and bear arms. I'm sure that those two intersect a whole lot, but there could be cases where they don't necessarily intersect, which is why we see lawsuits on things like billy clubs and stuff like that, right? So that makes sense. So if we can go back to the mandate now. So the mandate is a partial stay. I already tried doing my thing, but I don't have years and years of experience in the legal world like you do. Can you explain the partial stay on this mandate? And also, I am curious about the time clock because we haven't had that time clock of 90 days put on us for this specific portion before. Can you explain that for me?
Yeah, well, first of all, the 90 days is going to be extended. The mandate basically just maintains the status quo. And this is how it's been since we first filed the lawsuit, won, and then the state took it up on appeal the first time around. They said, we're not going to try and go after magazines that were previously possessed, magazines that were grandfathered in under the first law that basically banned the acquisition of magazines. Then you had Freedom Week, where the ban on acquisition was wiped out for a week, and people acquired probably 1 million 10-plus round magazines in the state of California. So there's these people out there that were grandfathered in before the law first passed because they possessed them before the law first passed that banned the acquisition, or they acquired them during Freedom Week, so they acquired them then. But after that, you couldn't acquire anymore. And the second part of the law would have banned those grandfathered and Freedom Week magazines, would have made it illegal to possess those too. So to maintain the status quo is if you have them, you can keep them, but you can't get any more until the ban is struck down. or upheld. If it's upheld, if the Supreme Court doesn't take this case, then all those magazines which were grandfathered in or bought during Freedom Week become illegal to possess as well. But we're not there yet. The status quo is you can legally possess those previously acquired magazines. You just can't get new ones. And the 90-day timeline is just, the Ninth Circuit said, 90 days, because that's just a way to say, get your thing into the Supreme Court. Because if it's in the Supreme Court and it's not decided on yet, then the 90 days gets extended. And it will be in the Supreme Court. Whether they take it or not, we don't know yet, but we're certainly going to file. I mean, we're in the process of getting the filing ready now so that we can ask the Supreme Court to take the case.
In your opinion, what is the level of the Supreme Court being compelled to take a case like this? I know that we've sort of mentioned the Ocean State tactical case. It's up on interlocutory appeal. This one isn't. This one has a judgment. How compelling is it for SCOTUS to take a case like this when, again, I know that all the talking points on this lawsuit have sort of revolved around whether or not Californians should be able to acquire, but you also have this piece where you could argue this is a seizure of property by making all of the ones that currently exist here illegal to possess.
We have a takings claim in there, too. Look, this case, it's fully baked. It's been tried not once, but twice. Tried in a district court, trial court, all the evidence presented, all the expert testimony presented, everything cross-examined, everything evaluated by the trial court judge, then evaluated twice three times by appellate courts, and it's a judgment as opposed to an appeal from a preliminary injunction. This is a permanent. The trial court issued a permanent injunction and judgment. That's what's being litigated. That's what the court seems to be looking for. We know, I think we know, that the Supreme Court is looking for a Second Amendment case. We don't know which one is going to be more or less attractive to the Supreme Court, but if we assume that they don't want these interlocutory appeal cases, the appeals from a preliminary injunction, they want a fully baked cake. They want a cake that's been tried and there's a judgment. That's Duncan. This is a case that's en banc with the Ninth Circuit, which is the most overturned circuit in the country. 4 vigorous dissents out of the 11, all of which lay out why the 7 judges are wrong and how they twisted the Bruin methodology, and they call them to task for that. So this case is really packaged. There shouldn't be any more that the Supreme Court needs to take a Second Amendment case and set the record straight about what the Bruin test really means and how to apply it and how the lower courts are twisting it and basically give them a smackdown so that they get the Bruin decision right. This case I think has, 10 out of 10 attractiveness to the Supreme Court, given the things that we think the Supreme Court is looking for. Now, that's not to say they could not take Snopes, the semi-auto case, but remember, that's a semi-auto case. See, they could straighten things out with a magazine case and not have to get into semi-autos if there's political resistance to that. Although I don't think the Supreme Court is too concerned, but hey, you never know. There is politics in Washington. So if they don't want the politics of semi-autos, well, they could do a lot of correcting in the context of a magazine case, because Duncan doesn't get into the rifles. It just gets into the magazines. Now, there are a couple other California, CRPA has a semi-auto case, and a couple other groups have semi-auto cases in the Ninth Circuit too. And ultimately, Snopes, they may take it. Ocean State Tactical is a preliminary injunction magazine case, so that's not attractive to them because of the preliminary injunctions stay. But they still might do something with it. So we just got to wait and see.
Yeah, I've been looking for a lot of answers kind of surrounding that Snopes case, and I'm sure that there are plenty of instances where cases stay on that order list undecided for several conferences, as Snopes has. There seems to be a lot of rhetoric around the fact that there could be that they're looking for a better case, but they kind of want to signal that they want to take a Second Amendment case. I've heard other takes, perhaps the Supreme Court is trying to write a majority opinion before they even decide to take the case. I'm kind of curious what your thoughts are on Duncan specifically. We had Bruen, and Bruen didn't address the magazine ban specifically, but it did give us a scope by which we should view Second Amendment cases. We could hope potentially if they take the Snopes case to do the same thing. What are the chances that a case like Duncan goes up to that and just sits on the order list as Snopes has? Or do you see a different scenario where they either accept it to specifically address the magazines, or they just say, nope, what the Ninth Circuit decided is what they decided?
Well, I mean, those are all possibilities. The court, it takes 4 votes to take a case, 5 votes to win one. Over the years, we've had Justice Scalia vote against taking cases when he was on the court because he knew he didn't have the 5 votes to win. But I think we have at least 6 votes to win the right Second Amendment case. Now, Snopes could get accepted. If it gets accepted, then Duncan would be held behind Snopes. And you might get another GVR, which is what happened with Bruen. Duncan was up in the Supreme Court. They decided Bruen rather than, so they accepted Duncan, vacated the lower court ruling, remanded it back down. They never argued Duncan the first time around. They just vacated the en bancs.
Well, that sort of is like the question that I'm asking. If they take Snopes and Duncan is sitting there, what are the chances that it gets remanded back again for another case that didn't directly talk about the magazine issue?
It might, because the Snopes case is going to have to address the methodology and to some degree examine what the right to keep and bear arms really means. So they could decide to accept Duncan, hold it, decide Snopes, then say to the Ninth Circuit, look what we just said in Snopes, reconsider what you said in Duncan in light of what we just said in Snopes. I hope they don't do that, because that sends us on another 2-year odyssey. Because the en banc court will try and play games and send it back down to Judge Benitez, where we will, of course, win. It'll only get stronger. Then we'll be back up in the en banc. So hopefully the Supreme Court will take Snopes and Duncan, because they are kind of complementary cases. But this becomes reading tea leaves. We never know exactly what the Supreme Court's thinking. They tell you a lot in dissents. And statistically speaking, by the way, I think Snopes has been postponed or reconferenced 9 times, rescheduled 9 times. That's typically a signal that one of the justices or more than one of the justices are writing that they're not going to take the case, but one or more of the justices wants to and is writing a dissent about why they should. And that's where we might get some clues about what the right case would be to get up to the Supreme Court that they will take.
I see. Well, I mean, certainly the take here seems to be that Duncan is ripe for the Supreme Court. So I guess just as a final question, how do you see this one moving forward? I know that we always want to say what we hope for, obviously there can be many conferences without them taking a case. How is it that you see Duncan moving forward from where it is now?
We will be filing our petition for a writ of cert in the United States Supreme Court shortly. The court can then sit on it. I mean, they go out of session in June. They don't come back into session until the first Monday in October. So even if they take Duncan, it's certainly not going to be heard this year. It'll be heard sometime in the next session, beginning October. So it's still going to be a while, unfortunately. And I know how frustrating that is. Believe me, it's frustrating for me too. In a perfect world, they would take Ocean State Tactical and they do a per curiam opinion. They don't even need to hear argument, that they can just say that the court in that case applied the wrong methodology. They could correct it, and then we could file a notice of ruling in the Duncan case and ask the Ninth Circuit on our own to reconsider it based on what the Supreme Court said in Ocean State Tactical. But this is, it's chess, not checkers. We've got to watch a lot of different moves and just try and play off them as best we can. In the meantime, folks, if you can help support the CRPA, we've got a lot of cases in motion, a lot of motions that we have to file in the cases, legal briefs, and we work for greatly discounted rates, but it still takes time, and time is money to keep these cases moving. It's a historic time. We are going to win. We are going to get a lot of things knocked out, but there is a resistance, a judicial resistance, a political resistance, the blue resistance to this change. Meantime, though, the Trump administration is doing some things that are very helpful. Pam Bondi formed a Second Amendment task force. The United States Department of Justice is investigating CCW delays and high cost practices in a couple of jurisdictions in California, and we are working with them on that. So there's a lot in play. CRPA is right out there in front in California. And in addition to, don't forget, we do it all, the programs, junior shooting, women's shooting, all the training programs that we have. We don't just do litigation. We're the one that want to get people out to the range pulling triggers and safely. And so, all those things need support, and we appreciate you helping out.
Well, certainly when you're pretty certain that you're gonna win in the end, the waiting does end up being the worst part of it, which is why it's good to remind ourselves of these nuggets that a lawsuit like Duncan has been working for us this entire time. It's been keeping at bay the law that would criminalize the possession of those magazines if you were grandfathered in, which, by the way, Freedom Week ends up being a grandfather for that as well. Chuck, I know that you're a busy guy. I want to thank you for coming on and sharing all this with us.
Anytime, guys. Happy to talk to you anytime you like.
Absolutely. And guys, if you want to continue and see content like this, you want to continue the updates of Second Amendment litigative and legislative efforts, please, as always, be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to those efforts to keep the ball rolling in the right direction for the Second Amendment here in California. Thanks again, guys, and we'll see you on the next one.